How to notarize for a signer who has power of attorney. As a notary public, you already know the basics of how to notarize for an individual. Today, we're going to talk about a special circumstance which may come up, notarizing for the representative of an individual. Often, military personnel based overseas assign another person to conduct business and sign documents for them. Or it could be an elderly person with dementia who had to appoint a relative or a friend to sign for them. The document authorizing someone to perform duties on behalf of another individual is called a power of attorney. The person granted power of attorney to sign documents for someone else is typically referred to as the attorney-in-fact or agent. The attorney-in-fact has the same authority to sign the principal's name and have that signature notarized without the principal present. The individual being represented is referred to as the principal. The principal is the one who signs the power of attorney document, granting attorney-in-fact status to another person. First, let's talk about the power of attorney document itself. If asked to notarize this type of document, it is important to check your state's regulations because some states have special rules for you to follow. For example, California requires the notary to obtain the signer's thumbprint. Now, let's talk about notarizing for an attorney-in-fact. When an attorney-in-fact signs a document for the principal and comes to you to have the signature notarized, typically they will sign the document with two names, their own and that of the principal. Let's say the attorney-in-fact's name is Catherine Vega and the principal's name is John Vega. Catherine could sign Catherine Vega, attorney-in-fact for John Vega, principal, or John Vega by Catherine Vega, attorney-in-fact. In this case, Catherine is the only person physically present before you, so you would write her name in the appropriate parts of the notary certificate wording. For example, personally appeared before me, Catherine Vega. You only need to verify the identity of the attorney-in-fact and not the principal. The same thing goes for your notary journal. The attorney-in-fact signs their own name. You should note in your journal, however, that the signer was acting as an attorney-in-fact and include the name of the principal being represented. So how do you know someone has the authority to sign for another person? Some states, like Hawaii, require attorneys-in-fact to present the notary with the original or a certified copy of the power of attorney document. Other states, like Idaho and Minnesota, require notaries to verify the attorney-in-fact status through personal knowledge or by requesting written proof. If your state does not address this, the NNA recommends asking the signer to state out loud that they have the authority to sign on the principal's behalf. What about jurats? If an attorney-in-fact requests a jurat, they may only swear or affirm in their own name. Taking an oath or affirmation in the name of another person is generally not permitted. Finally, let's talk about notary certificates when it comes to notarizing for an attorney-in-fact. It's not so different than other notarizations. You're still notarizing for an individual. If your state does not specify attorney-in-fact wording, then just use the appropriate standard certificate for the acknowledgement. Remember to check your state regulations and always make sure to use the appropriate wording required before you proceed. We hope this information helps you the next time you encounter a request related to an attorney-in-fact. To learn more, click the links in the description below or call the number on your screen.